Hi, this is Ennis from Never Stop Trucking. We are talking about FMCSA finally saying something about dispatchers, and it is good in my opinion. It's very good, and finally we have a ruling where FMCSA actually talks about us. There have been a lot of discussions on internet and YouTube about whether dispatching is legal or illegal, and I also have a video that I made about that a while ago. But now finally they came up with something where actually mention dispatchers, and I've seen a few videos that try to spin this around there and saying that we do need a bond, and be a broker and all that. But according to the language by FMCSA, we don't. So I'm just gonna start with reading these 6 factors that will help determine whether you should be considered a broker or just a dispatcher like we are. So let's go to that language right now. The first point here that they made, and I'll read the first sentence first. So it says here, to make the distinction, meaning between brokers, freight brokers and dispatchers, the FMCSA listed 6 factors to help determine if a dispatch service needs broker authority. Such authority, meaning the brokerage authority, is needed if the dispatch service, and then they have these 6 factors. So let's start with the first one. If the dispatch service interacts or negotiates a shipment of freight directly with the shipper or a representative of the shipper. Most of us don't do that at all. Most of us find loads on load boards, or we contact brokers directly. And of course, we book those loads in the name of that carrier, not in our name. So it's a transaction between the carrier and the broker. I know some dispatching companies are advertising that they have direct shipper freight, and some of them are calling me. But in this case, if they actually do that, if they actually have that freight like they say they do, and honestly, I don't believe that they do, it's just their way of getting carriers on board. But if they actually have direct freight from a shipper, then that means they will need a broker authority, and that's normal. I would say that even before this, that if they're involved in transportation of goods in that way, then if someone had asked me, I would advise him to get the broker authority even in that case. But most of us, like 99% of dispatchers, don't deal with shippers directly. Second factor here says accepts or takes compensation for a load from the broker or factoring company, or is involved in any part of the monetary transaction between any of those entities. And I have been saying this all along when I made my argument about dispatchers being legal, is that we are not involved in any of these transactions. We at no point of the transportation of the product own the load, whereas the broker actually gets the right to move that freight, and the broker actually gets paid directly from the shipper, and then the broker will pay directly the carrier. At one point of the time, the carrier is in actual possession of that load and is involved in a transaction. So that means that the carrier will need their authority and the broker will need their authority, but we as dispatchers are not involved in any of these transactions at all. The only transaction that we get is a payment from the carrier for our time, where we used our time and our resources to find a load that's already being posted on a load board, and then we book it in the carrier's name. Third factor here, arranges for a shipment of freight for a motor carrier with which there is no written legal contract with the motor carrier that meets the aforementioned criteria. This is a little bit unclear, but basically the motor carrier has to have a written agreement with someone to move that load, whether it's the shipper or it's the broker. In our case, it's usually the broker because we get the load from brokers. Then a carrier has a written legal contract, meaning the rate confirmation is signed by the carrier, and that rate confirmation is forwarded to the carrier, and they're using that rate confirmation as a proof that they have transported the load and that they have done so legally. Okay, so a carrier basically has to have a written contract in place between the carrier and the broker in order for them to move that freight, and we always have that anyway. Fourth factor: accepts a shipment without a truck carrier, then attempts to find a truck carrier to move the shipment. This could be very tricky for you as a dispatcher. It used to be that we would be able to book a load and try to find a carrier after that. Now that was also hard because in order to book a load with the broker, they need an MC number to book that load under. So when you're booking a load, they always ask for MC number for your carrier, and they will book that load for that carrier. So it would be very hard to book a load from a broker without having a carrier. But it was possible if the carrier knows you, if you have a good relationship with them, or under special circumstances they will get you some freight. Then you will be able to give that freight out to your carriers. Now you can't do that anymore, and like I said, not many dispatchers have been doing this anyway. Probably 99% of dispatchers would only book a load when a carrier needs the load. Sometimes trucking carriers that have their own authority would book a load like this, and that's legal because they can get the freight from the broker in their own MC number, and then they would just assign it to their trucks, no matter if they're owner operators, but they are leased under that carrier anyway, so they can do that. With us dispatchers, we can't do it. So if you are doing that, then you should stop. Then you could be considered a freight broker, and you will need your license with FMCSA, your authority with FMCSA in order to do that. But most likely you're not doing that anyway. The fifth factor here is a named party on the shipping contract. So if for some reason your dispatching company is named on any of these shipping contracts between a shipper and broker, shipper or carrier, broker and carrier, then you could be liable for that. You could be held liable, and someone could argue that you are actually a broker. But like I said, for all of these factors before, that probably almost never happens anyway. The broker will always book the load under carrier's authority. Usually they don't even ask you about the name of your dispatching service. Sometimes they don't even know that you're dispatching service. You just call a book, you have a power of attorney, you can book a load in for that carrier. You just act as their agent. That's all you're doing. So usually they don't even ask you for a dispatching company. So this is not the case anyway. And then the fifth one is soliciting the open market of carriers for the purposes of transporting a freight shipment. Now this one could get a little tricky. Everyone that was advising you guys how to find the owner operator would sometimes say, hey, just go out and find a load and maybe offer that load to a carrier that's posting an available truck. And this could maybe fall into that category. So if you have been using that search trucks option on DAT board and then offering a load that you don't even have, or maybe that you do have, then that could also mean in that case that you could be classified as a freight broker. So if you have been doing that, I would stop doing that. And usually that doesn't give out good results anyway. So if you're soliciting the open market of carriers, trucking companies, and you call them and say, hey, we have these shipments come on over to us, we have constant freight, then maybe you shouldn't be doing it that way anymore, because that means that you do have constant freight and you're just looking for those carriers to move that freight that you already possess. So you shouldn't be doing that. I haven't been doing it anyway so far, because it's as a dispatcher, it's hard to have constant freight that brokers will give you. Usually we have to rely on broker boards and availability of the drivers, wherever they are. Then we post them out of that area and then we look for a load. Now this last factor could mean a lot to you, because a lot of dispatching companies are doing it that way. And then just keep in mind that you can get charged up to $10,000 for each violation. So you should read these, study these, and avoid at all costs some of the things that we talked about. And maybe you could even talk to someone who knows more about these loads, a lawyer or someone that has a lot of experience, and then maybe they can come up with another interpretation of these. But basically, most of these things we haven't been doing anything. If you haven't been doing some of these things, then you should stop and just concentrate on being a dispatcher and making sure that you're legal. Now, at least you can say to everyone who argues that dispatching services are illegal, in general, then you can argue that FMCSA has made a ruling, and that only if you're doing these, then you are a freight broker. And they also, I will include this text. There are other articles that talk about this online. I will include this article in the video, but you can actually read the whole article, where it actually mentions dispatchers, and it says that they are helpful to trucking carriers, and it acknowledges our presence and the need for trucking dispatchers, and it doesn't classify them as anything bad or anything shady like people are trying to say. But just don't do any of these and you'll be fine. This is Anis from Never Stop Trucking. Thanks for watching. And then if you're a carrier and you need us to find you freight, then we will be happy to do so. Go to 3blogistics.me. Thanks for watching. See you guys around.